All right, let's come back to order. All right.
Now, before the jury returns, Your Honor, the next witness we intend to call is Luis Santiago, father of baby Antonio. Your Honor, we had a motions hearing yesterday regarding witnesses Sandra Holboy and Angela Carter in connection with a motion to dismiss for outrageous misconduct. That motion was denied. The court did hear evidence at that time in the form both of a proffer by way of the contents of the motion itself and actual testimony from both of the witnesses describing some but not all information that the defense believes is relevant to the case at hand. Your Honor generally referred us to the rulings of the morning with respect to the admissibility of certain conduct and statements of Sherry West. Your Honor, specifically prior incidents of child abuse and drug use. Your Honor, those rulings are similar in some ways to the issues before you now, but in other ways very different. The same authorities cited by the court, Scott v. State and Dodd v. State, would be the starting point for the analysis, but we believe the actual analysis itself is quite different. Of course, Mr. Santiago has gunshot residue on his hands. That's already been put into evidence. I don't see how anything relating to his possible role in this crime can be considered collateral, and certainly the fact that he had threatened to kill children on 2 other occasions and further taunted the people he was in relationships with statements like, "I'll have an alibi and they'll never know it was me and they'll never find the evidence," and that's a gross summary of what the court heard in specificity by motion and in the way of the testimony. There's no question that those statements are admissible under the authorities previously cited. Now, some of the other...
Which statements now? I mean, the statements that he I mean, anything that happened while he was at the hospital, is that what you're saying? I mean, other than the...
Certainly anything he said at the hospital.
Other than the privilege.
Certainly anything he said at the hospital we can go into.
Certainly.
Even with respect to privilege matters, if he said them in the presence of other people, then they wouldn't be privileged.
Well, I think we established yesterday there was only one statement that's privileged, and that's going to be the one that was just with him and the pastor alone. All the rest were inside the...
No, sir. I'm sorry. I didn't mean any disrespect. I wasn't trying to cut Your Honor off. All we heard from yesterday was Reverend Culpepper and what he heard.
Right.
But if Santiago said other things before or after Reverend Culpepper was present and alone with him, I mean, I think that is affirmatively what the state intends to put up in their rebuttal. Those statements would not be governed by the court's ruling yesterday. Moreover, any
I ruled that way yesterday.
Yes, Your Honor. Now, with respect to Ms. Holboy and Ms. Carter, as you recall from the testimony yesterday, during a domestic dispute, Mr. Santiago threatened Sandra Holboy, specifically threatening to hire a quote-unquote crackhead from quote-unquote the city, a city subsequently identified as Minneapolis, to kill her and her children, and that he would have an alibi and that nobody would ever know that he was responsible. Ms. Carter, also Ms. Holboy reports that Mr. Santiago lied during his testimony at the motions hearing when he suggested that he was not familiar with gunshot wounds, when in fact his sister was shot to death in New York and he was present for the open casket funeral. And her testimony was specifically, he knows what a gunshot wound looks like. Your Honor, now there are some other statements that are less direct. More to the point, Ms. Holboy stated that she called the local police department when she learned of the death of Antonio Santiago, and because she suspected that the father, Luis Santiago, may have had a role in the death of baby Antonio. And she described yesterday in great detail very specific information she provided the police, information which the state has never turned over to the defense in this case. And again, Yesterday, the issue was whether or not there was a duty to disclose that was violated. Today, the issue is the credibility of the law enforcement investigation in this case. The defense theory from day one has been that the state and police deliberately investigated this case with blinders on so that they wouldn't deliberately engage in willful blindness, I believe would be the federal speak for that, exercise willful blindness so as not to learn of any information that would contradict the desired result of their investigation. Your Honor, to that extent, the statements of Ms. Holboy during that conversation with the police department are relevant not for the truth of the matter asserted necessarily, but relevant to establish the theory of the defense is with respect to the blinders or tunnel vision with which the police investigated this case. Likewise, Ashley Glassey has already provided a similar testimony, and Angela Carter, Your Honor, also indicated that while she was in a relationship with Mr. Santiago, that he attempted to kill her while she was pregnant. I believe she indicated he attempted to run over her with a truck, and that during, I believe it was that same dispute, Mr. Santiago threatened to kill Ms. Carter and her family. He boasted, "By the time they find your body, they won't be able to identify you," adding, "Your family will never see your daughter again." Your Honor. Now she also goes into a number of other incidents that I won't review. They're in the written motion that we filed, and we would ask the court to include that as well as the testimony yesterday, the live testimony, in support of the proffer. But again, she also testified in great detail yesterday at the hearing that she contacted the police department here, locally in Brunswick, and gave them identifying information, very specific information, to alert them to the importance of the information she had. And again, the police department did nothing to follow it up and did not disclose it, Your Honor. Similarly, Holboy testified specifically that Mr. Santiago blamed her for the death of their son, just like he did to Miss West in the emergency room, and subsequently in the domestic, one or more of the domestic disputes as to which the court has already heard proffers and testimony, Your Honor. For all those reasons, first, constitutionally, as far as our right to confront witnesses, we're entitled to go into that information with Mr. Santiago. There can't possibly be any question here, and I'm referring to the language in Dodd, as to whether the proffered evidence raises a reasonable inference of the defendant's innocence. Your Honor, the Georgia Supreme Court has ruled that a reasonable inference of the defendant's innocence was raised by evidence that rendered the desired inference more probable than the inference would be without the evidence. And there can be no doubt that the suggestion that he's innocent and that someone else did it, in this instance, Mr. Santiago, there can be no question that that testimony makes that defense more likely true, Your Honor. These statements are admissible as substantive evidence as to the truth of the matter asserted. They're also admitted for the limited purpose of establishing the shoddy tunnel vision with which this case was investigated by the police departments. And for both those purposes, the testimony in question is admissible.
Anything further?
Your Honor, we're asking the court to rule on that, and in the event that we have an unfavorable ruling, we would nevertheless, although we do not believe any of this.
You're asking the court, one, of course, to rule on the admissibility of the testimony of basically what you can ask Santiago, and then of Holbrook and Ms. Carter, correct? And then,
yes, I think you covered.
Okay. And are you still needing a ruling as to Pastor Wright? I think Pastor Wright Culpepper.
I believe Pastor Culpepper. I believe the court's already covered. But we do need a ruling with respect to the admissibility of Ms. Holboy and Ms. Carter, with respect to whether, if the court's going to impose any limitations or allow it only for a limited purpose. Before we examine them and examine Mr. Santiago, we would certainly like to know that. If the court is inclined, and however wrong we think it is, to rule that some of this is collateral for some reason, we would want to verify that we will nevertheless be allowed to ask Mr. Santiago about the same information, whether or not the court, pursuant to the court's interpretation of the 600 rules, whether we're going to be allowed to go beyond the answer provided by Mr. Santiago with Ms. Holboy and Ms. Carter. So there's a potpourri of rulings required and clarifications required from the court. We weren't required under the rules to bring this to the court's attention before we entered into the examination of Mr. Santiago. But given the importance of all this evidence and the potential impact on the case, we did think it was appropriate to ask the court to address it in specificity before we went into this next round of witnesses.
Anything from the state?
No, Your Honor, everything that the state said yesterday we incorporate in response to that.
The law is quite clear that for a defendant to introduce evidence implicating Santiago in the commission of a shooting death of his son, that proffered evidence must have a reasonable inference of the defendant's defendant's innocence. It must directly connect Santiago with the corpus delicti or show that Santiago has recently committed a crime of same or similar nature. That burden is on you, Mr. Goff, and the court finds that you have not met that burden. Evidence that merely casts a bare suspicion or another raises a conjectural inference as to the commission of the crime by him is not admissible. The court finds that after hearing Sandra Holboy's testimony yesterday, she was married to Santiago for 12 years, during which time, according to her testimony, Santiago was abusive, both mentally and physically. He was addicted to drugs, that he made horrible threats to her life and their children's life. She admits, however, that she hasn't seen or been in his presence, I believe is what she said, for over 15 years. She hadn't spoken to him in the last 6 years. Said that she called law enforcement to tell them of her experience with Santiago because she suspected that he was involved. The next witness, Angela Carter, another ex-wife, but she was engaged. They had children together. In her testimony, as I have it noted, she recanted similar instances of abuse and addiction again, though she admits that her relationship with Santiago ended over 10 years ago, and that she reached out to law enforcement because she too suspected Santiago could have had something. Their speculations based upon their relationship with him 15 years ago, 10 years ago, is nothing more than just speculation. Neither of them place him at the corpus delicti of the crime, nor do either one of them show that he recently committed a crime of the same or similar nature. Therefore, any questions, unless they have some admissible testimony, relevant testimony as to the crime that we're on trial on, your permission to question those is denied. You want to take exception? Go ahead.
Well, we take exception under the constitutional confrontation issue and due process arguments previously raised, Your Honor, under both the federal and the state constitutions. Beyond that, we need further clarification from the court.
Okay.
Your Honor.
As to Santiago himself?
As to Santiago, will we be able to be allowed even to inquire, knowing that we cannot follow up with the actual testimony of the witnesses? Mr. Santiago doesn't know that, presumably, and therefore we would at least like to be able to.
You can ask him relevant questions on direct examination of where he was in the time frame of this shooting. I'm not going to allow you to go into his marriage of when he was married 23 years ago and domestic problems that he had and his version of what we heard last night. I'm not going to let you ask about the engagement unless you can. The court has found that they have no connection. That these ladies, these ex-wife and ex-lover, that their troubled relationship with him, and that their speculation that he had something to do with it is merely just that. And so we're not going to proceed with that here in the trial.
I understand the court's ruling on that.
Okay.
And further, is the court going to allow us to present the testimony of Sandra Holboy and Angela Carter for the limited purpose of supporting the defense theory that the prosecution and the state in this case investigated this case with blinders and failed to follow up on obvious leads?
No.
Well, I'm glad I asked the question. Your Honor, with those rulings by the court will give us 5 minutes. We've got some witnesses to release, and our next witness will be Mr. Santiago. But we also take exception to the court's rulings with regard to that.
I understand.
And also,
Be noted.
I want to put it on the record, 'cause I don't think it's going to change the court's ruling. We also contend that the testimony of Sandra Hallboy and Angela Carter raises a reasonable inference that the killing in this case was a drug-related act rather than the product of a random robbery. And Your Honor, we'll also direct your attention specifically to the testimony provided from both witnesses that Mr. Louis Santiago had a bad crack habit during the time of both of those relationships, and that he in fact stole the wallet of Angela Carter, acknowledging that he owed money to a drug dealer and that he needed to pay off the drug dealer so that they would not hurt him. We contend that that raises a reasonable inference as to whether the same conduct and motives are at play in the death of baby Antonio.
It'll be so noted for the record, Mr. Goff.
Thank you, Your Honor. If we could have 5 minutes.
Okay.
We just shortened it.